SJC-10234, Commonwealth versus Hubert.
Good morning, Counsel. Is it Kanan or Kanan?
It's Kanan, Your Honor.
Kanan, thank you.
Good morning. May it please the Court, Karina Kanan on behalf of the Commonwealth. It's not in dispute here that the trial judge gave the pre-2003 amendment to the OUI law instruction. What is in dispute is that that instruction could have had any effect on the jury given the overwhelming evidence, apart from the breathalyzer evidence, that this defendant was under the influence of alcohol. The most damning of this evidence was the fact that while he was being stopped by the state trooper, the defendant began urinating into a styrofoam cup, told the trooper that he...
Wait, I think you forgot one already. He was observed swerving back and forth. And
oh, yes. No, I'm not going in chronological order. I would just start there and say, you know, the most obvious evidence of this overwhelming evidence of the defendant's intoxication was that bizarre behavior of urination right in front of the trooper, and then that he threw the cup out the window such that the trooper had to jump out of the way to avoid that. I would argue that in conjunction with his putting out his lit cigarette with his finger after he'd thrown a cigarette carton out the window, again, all during his stop, together with later on at booking exhibiting severe mood swings was the testimony. He'd go from being calm and polite to swearing and yelling, to stating at booking that he'd walked the line perfectly straight. In fact, he had not been asked to walk any line. Again, and to continue, the two failed field sobriety tests here, they were not physical failed sobriety tests, they were verbal. One was simply to recite the alphabet. The first time the defendant did this, he had trouble getting past the letter C. He mumbled letters. He was asked to do it again. He mixed letters. He made no sense. Ultimately, he never got past the letter P. The second verbal field sobriety test and not counting backwards numbers test, he was just asked to count backwards from 78 to 62. He uttered numbers in no sequential order. He mixed numbers. He was never able to get past 70. Again, even going on from here, then he had all of the traditional signs of that the court has looked to.
You don't think that the fact that the breathalyzer has some scientific aura, it doesn't give it special weight and consideration?
I would say not. I would say the court can say with fair assurance that given all of this other evidence, that it could not have influenced the jury where they had all of this other evidence in front of them. Certainly, also, the prosecutor never argued that evidence in closing. So while yes, the evidence was before them, it was never argued strenuously to them. The prosecutor simply said, you have before you evidence that the defendant blew a .16. The judge is going to instruct you on that. And that was all that he said in his closing. So the closing argument really stressed all of the other evidence of intoxication. So that is the Commonwealth's principal argument. However, turning to the other arguments in my brief, the error that did happen here was an error in the defendant's favor. What simply happened was that the judge instructed that the jury could give a permissive inference of intoxication, when what he should have said was that he should have told the jury that they needed, if they credited that breathalyzer evidence, that they should have mandatorily found that showed that the defendant was under the influence of alcohol, and that therefore, in essence, in this case, I know the argument could get a little convoluted because it's built layer upon layer, but the essence is that both theories were instructed on here. It doesn't really matter that we know from sidebar conversations that the judge had not informed himself, was not allowing himself to be informed that the per se theory existed, that the amendment had changed. What really matters is that he did instruct on this, and he gave the comprehensive instructions regarding the predicate findings that the jury needed to make before they could credit that evidence.
But the way I read the judge's pretrial ruling, and maybe I wasn't there, obviously, was that he limited the Commonwealth and restricted them from presenting a per se theory under this indictment.
It's not completely clear. There's a conversation about it. He says the Commonwealth is what he said precisely.
So I'm going to limit the Commonwealth, but I'm going to let the breathalyzer in, or something like that.
Yes, he does say that, and then he says, "We'll see." So then their opening arguments opening statements, the prosecutor does say that .08 is the legal limit, and the judge is going to instruct them on that. Defendant objects afterwards, and the judge says, we'll see, but, well, I can't correct them now. It's just something he's not going to be able to deliver. Then they go on. It was a matter that was revisited as the case went on. But my point is simply that that all of the predicate instructions were given. If the court looks, it's in my statement of the facts on pages 10 to 11, the judge's instruction on the breathalyzer. He tells them, you need to find that the breathalyzer test was scientific. You need to make the findings that the evidence was scientifically administered, properly administered, and scientifically accurate before you can credit it. Also, in this case, the breathalyzer test was administered well under 3 hours. It was administered less than an hour and a half after the defendant was pulled over. So we know that if the jury did credit that evidence, they made those predicate findings first, that it was scientifically accurate, that it was properly administered, and we know that it was given in under that time. So really the only error here is the judge's instruction where he simply said may instead of must. And where that's the only error, that error inured to the defendant's benefit here. He got a benefit from that instruction.
You're saying that the judge gave the jury the instruction he should have given?
No. His error was to say, you may use the .16 to infer the defendant was intoxicated. Had he been following the instructions, he should have said, if you credit that .08 finding, or the above .08 finding, you must find him guilty of OUI. So the defendant benefited from that instruction. Of course, the judge also instructs on being under the influence. So in essence,
I thought the Commonwealth was proceeding on an impaired ability theory.
The Commonwealth kept attempting to proceed under both theories, Your Honor.
And that's why I think, I guess I read the court's ruling as saying that the Commonwealth can only proceed under the theory they have specifically charged.
Yes, and I think that's because he didn't recognize, yes, that's
which was not .08.
Which was not .08. However, as I say in my brief, like I say, the argument is layered. There's really one offense here. There's OUI. There are just two methods of proof towards getting that last element.
I know that's what you say. Mm-hmm. You look at the statute. It says you're guilty. There are, where is the statute? Whoever upon a way operates a motor vehicle with a percentage by weight of alcohol in their blood of 0.8 or greater violates the law, or while under the influence of intoxicating liquor violates the law, or under the influence of intoxicating marijuana violates the law.
Correct. But I would submit to the court that it's discussing two methods of proof for conviction under OUI, and that the same three elements exist as ever: operation, public way, diminished capacity under Connolly.
No. Well, there's no diminished capacity is required for the first.
Well, it's certainly never stated that in the statute. However, even now, if the court looks at the state of the model instructions, which were revised, that came out in July 2007, Note 1 states the two alternatives comprise a single offense that may be committed in two different ways. So the Criminal Proceedings Committee currently, which issues these, this is the state of understanding here in Massachusetts, is that there is one offense and that there are two methods to proving that. I would argue that that is what makes sense.
What did the complaint read? The
indictment.
The indictment.
The indictment indicted that he operated in public way under the influence of intoxicating liquor. My argument is that was sufficient, that much like with first-degree murder or with assault, you just have to charge assault or murder. You don't have to list your theory there. And per se is a theory. It's a method of proving that final element. And I think the evidence of that is, we have to guide us here. We have the statute itself, and we have Commonwealth v. Cultori. And I would say in both, arguably, we go back and forth on whether there are two offenses and two methods of proof. The court does mention in Cultori that when it's discussing the 2003 amendments, that there are now two ways that you can prove it: by proving above .08 or by proving he was under the influence. But then, of course, throughout the opinion, it refers to the two theories. So it never... the court's not referring to it as two offenses, two theories. Then in the statute itself, obviously there's the first sentence of A1A, as Your Honor pointed out.
I think in Cultori we do note that they actually charged in the alternative in that case.
They did, but the court doesn't say that that's necessary.
It wasn't necessary for us to decide whether it was necessary.
Correct. The further evidence, I would say, from the statute itself, certainly there's that first language, which, as you pointed out, Justice Cordy, does state in the alternative what I would argue are the two methods of proof. But then in Section E is very illustrative, because that discusses precisely why breathalyzer evidence is admissible. And it says in any prosecution under Section A1A, breathalyzer evidence is admissible and relevant for the purpose of showing that the defendant was under the influence of alcohol. So to ignore that, to ignore the meaning behind why the legislature amended the statute in 2003, it ignores what the essence, what the substance, what the meaning of greater than .008 means. The legislature essentially was taking legislative notice of the fact that you are under the influence of alcohol if your blood alcohol content is above that. You might not be driving erratically, but you don't need to be. You could be. They've essentially said you could potentially be a danger to the public. And therefore, that's another avenue towards satisfying that third element of OUI.
Thank you.
If there are no further questions, I'll rest on my brief. Thank you.
Thank you. Mr. Foley?
Good morning, Your Honors. Thomas Foley from Mr. Hubert. I'd like to start off by taking issue with the Commonwealth's idea that Mr. Hubert got a better instruction than he was entitled to, because that's simply not the case. He was entitled, especially after the court made its ruling, that the Commonwealth was not allowed to proceed on the per se branch of the statute. He was entitled to have no per se instruction and no permissible inference instruction read to the jury. But the permissible inference instruction was read to the jury. That should not have gone to the jury. And in fact, the breathalyzer evidence should not have gone to the jury at all. And this all comes from Commonwealth versus Colturi, which was decided after this case. In fact, it's not even cited in my brief. It was decided about a month after my brief. But my brief does a great job of anticipating Colturi. And
If you say so yourself.
But let me finish. I got to give all the credit to the trial defense attorney. I can't take credit for it because she anticipated all of it before Colturi and before I did. She did a fantastic job of raising this to the court. And the court initially made the right decision. There's no question what the court did. The court restricted the Commonwealth to the imperitability branch of the statute. The defense attorney got up and made a great argument in limine, saying that the Commonwealth should be restricted in its proof to the traditional mode of proving OUI. The judge said, motion denied. The motion is allowed as to restriction of the government, and then cut himself off and berated the defense attorney for having a compound motion. Defense attorney said, I'm sorry, Judge, I'm not clear on your ruling. The court, I said your motion is allowed. Maybe that's a little bit confusing. I think he was restricting the Commonwealth. But then we go after the opening statements when the Commonwealth stated that .08 was the legal limit. Defense attorney gets up and says, Judge, you just said it was a legal limit. You said there was going to be restricted. The judge makes clear at that point, if he didn't make clear before, he makes clear at this point, he's talking to the prosecutor, I told you before we started that he wasn't indicted on a per se violation. He was indicted just for operating under the influence of liquor. I don't know how you get that instruction. And then the court says, I never said I was going to give a per se instruction. The legal limit was 08 and a little bit below. You didn't indict him in the way that the statute was written after the change. You wrote it in the way it was written before the change. So that's what you're stuck with. So I don't think there's any question. The judge was saying, you're restricted to the traditional imperitability test. I'm not giving the per se instruction.
So what's the rule? Unless the Commonwealth specifically charges under the per se aspect of the statute, it's a default. It's a default provision. It goes to the imperitability section of the statute.
I think Colturi contemplates that they should be charged in the alternative. And the 3 or 4 OUIs cases I've been involved with since then, the Commonwealth has charged in the alternative. So I think they're usually doing it. In this case, they didn't.
Excuse me, you're saying that the Commonwealth needs to indict under the per se theory?
Yeah, they should indict.
To raise both.
To raise both. Just as in Colturi, when they point out, as in that case, they were indicted in the alternative. Both were just, Mr. Hubert, they could have said.
Okay, and if the Commonwealth doesn't, as here?
As in this case,
right.
Then they are restricted to the imperitability branch of the statute. They may not go under the per se branch of the statute. Now, you all might be concerned about lots of other cases that could or maybe are out there or maybe aren't out there where
And
this
that
happened.
issue, that issue really isn't up here in a way. I mean, it's
Yeah.
it's really not here. The Commonwealth didn't appeal the judge's ruling limiting them to one theory or another. It's just a question of how the case played out in the instruction.
Commonwealth didn't even really argue about this below, that, well, I should be allowed to do the, I mean, they made the argument, but then when just didn't seem to pay any attention to it, just kept proceeding under the per se branch of the statute.
I mean, you have to admit, it is pretty strong evidence of intoxication. What do you say about?
I certainly think the breathalyzer is incredibly strong evidence of intoxication.
I meant the other evidence.
Exactly. Well, I think in this case, unlike a lot of cases, you had a defense that really rebutted just about everything that the Commonwealth put in, and the appeals court agreed with that. The final part of the argument section of my brief goes through everything that the Commonwealth put in and shows how the defense rebutted it. For example, the reason for the stop was that Mr. Hubert allegedly went over the yellow line. Well, a private investigator came in and testified that there was no yellow line and that area was in a really rough shape. So right there, you've got a question. If there might have been an argument for motion to suppress that wasn't even a valid reason to pull the car over. But at the very least, it cast doubt on this officer's credibility and this officer's claim that he went over the line. Okay, so it took 700 yards for Mr. Hubert to pull over, but we had an occupant of the car explaining that Mr. Hubert didn't fail to pull over because he was intoxicated. He failed to pull over because he couldn't believe that the police officer wanted to pull him over and said, he can go around me. So 700 yards later, he finally pulls over. I don't think that's unreasonable considering that he knew that the police officer was there and he wasn't trying to outrun him. The police officer himself testified that within that 700 yards, he drove perfectly fine. So again, I don't think the failure to pull over until 700 yards later really meant much. You've got a lot of this stuff about his behavior when he was pulled over. He certainly was not respectful to the police officer. But you've got testimony from the occupant of the car, his good friend, that's Mr. Hubert. That's who he is. He's a very headstrong and
Yeah, but his failure to pull over is minor compared to the other things. For instance, urinating in a cup while a police officer's standing there. That doesn't seem to be too sensible a way to behave.
No.
And then throwing the cup out the window. So
no, it's interesting. It's obviously this is in the record. He just got in trouble for doing the same thing in prison. I can't explain it. He did it. But if that alone is the Commonwealth's proof that he was driving while under the influence, I think that's not a harmless.
But it isn't alone. It's also how he reacted to the instructions about the test and how he did the test.
Well, there were two tests, and apparently he didn't do that well. But then you've got the police officer at the station who did the booking who said he was fine. I didn't really notice any problem with the speech. I never saw him, start to tip over or topple over. He was handcuffed hands behind his back as he walked in the police station. He walked perfectly fine. There's a lot of evidence from the defense that rebuts a lot or pretty much all of the Commonwealth's evidence.
I take it your position is you rely on Flaubert. You say, look, the jury had evidence of .08 that was so damaging that even if you put up all these other things, some of which is rebutted, you can't slip away the .08.
Yes, I think if there were,
0.16, right?
I mean,
0.16.
0.16.
yes, I think if there were no defense to all the Commonwealth's other evidence, then I might have a harder time saying that it couldn't be harmless, that it wasn't overwhelming. But you've got that really powerful breathalyzer evidence, and then but on the other, which I don't see how it would be really difficult for any case to be considered overwhelming enough to overcome wrongly admitted breathalyzer evidence. Everybody knows what the legal limit is. Everybody knows.
No, everybody doesn't know.
Well,
everybody engaged in our profession knows what the legal limit is.
I think there'd be at least a couple of jurors that know what the legal limit is. The prosecutor, in fact, told them what the legal limit was in his opening statement improperly, and the judge failed to cure that defect. The prosecutor said the legal limit's .08, so they know that he was twice the limit. In this case, there was a good defense. The jury could have believed everything that the defense said, or none of it, but that, you know, that's not for us to decide. There was certainly evidence there for the defense, for the jury to say he was not impaired, if it were not for the breathalyzer evidence. So if there are no other questions, I'm content to rest on my brief, and especially the appeals court's decision.
Thank you, Mr. Foley.
Thank you, Your Honor.
All right.